Okay, according to my clock, it's 6:01, now 6:02 p.m., and it's Wednesday, March 22nd, 2023, and this is a special meeting of the Medical Marijuana Commission here in Pontiac, Michigan, in the Pontiac City Hall Council chambers. And I'll officially call this meeting to order. All right, Commissioner Pontiac, can we get a roll call?
Ford.
Here.
Wilson. Present. Porath. Here. Maley is not here.
Okay. Can I get a motion to excuse Commissioner Maley?
Motion to excuse.
Can I get a second? Got a move and a second. Roll calls. Mr.
Wilson.
Paul.
Try it again.
Oh, hey, give me a yes. Wilson.
Yeah.
Okay.
Pratt.
Yes.
Ford.
Yes. Okay. We have one amendment to the agenda, and that is to move public comment up to after the approval of the minutes. Can I get a motion?
I move that we move the public comments up to on the agenda before, after approval of the minutes.
Okay, second.
I second.
Okay, it's been moved in a second. Okay, roll call.
Pratt.
Yes.
Ford.
Yes.
Wilson.
Yes.
Okay. Can I get a motion to approve the agenda as amended?
I move that the agenda be approved as amended.
Can I get a second?
Second.
Got a move and second. Okay. Roll call, please.
Pratt.
Yes.
Ford.
Yes.
Wilson.
Yes.
Thank you. Okay. Can I get a motion for the approval of the minutes for June 2nd, 2022, as well as December 27th, 2022?
Motion to approve.
I support.
Okay, it's been moved and supported. Roll call.
Ford.
Yes.
Oh,
Wilson.
Yes.
Pratt.
yes.
Okay. All right, the next item is public comment. Anybody who has anything, please come to the podium, identify yourself, and you will have 3 minutes.
Oh, so it's gonna look like a person.
Right here? Okay. My name is James Allen. I'm counsel for Nature's Remedy, and given the time period that is allowed, I will be brief.
Let me stop you for a second while we get this timer set up, and please excuse me for that. Okay, all right.
All right, I'll take 99 hours. I'll just bore you all into doing what I want you to do.
Okay, sir, go ahead.
Ready?
Yes.
Okay. I understand the jurisdiction of this commission. You have some limited authority to award points here, and why you should award the points is contained in the brief. The decision by the hearing officer to deny the points based upon the absence of a traffic study that does exist and was submitted is a clear error on the part of the hearing officer. And the requirement, as it were, that a signed and sealed scale diagram be submitted is not contained in the ordinance. It's not contained in the application. The only thing in the application is that it's required to be in the form of a a scale diagram that is prepared by a professional surveyor. That's what you have. That's what the hearing officer had. And that, quite frankly, is the basis upon which Nature's Remedy was the 5th place finisher and awarded a license with a conditional approval. None of the conditions in the conditional approval had anything. There's not a word in there about common citizens' appeal being resolved in favor of the city being one of the conditions for my client. Now, this is an issue of fundamental fairness that you have to confront. My client is the only applicant that pulled the permits, went through the planning process, was issued multiple approvals in the planning process. All of it spelled out in your packets. But more than that, expended a great deal of money and effort in furtherance of getting his dispensary up and running. The only licensee that you have in the city that had made it to that point when the rug was pulled out from underneath my client. It's an issue of fundamental fairness. I believe that ultimately, if the commission here tonight doesn't award the points that my client lost, and actually I think I misspoke, the only issue that we're dealing with here is the signed and sealed issue on this particular one. But if you fail to do it, the issue is going to be resolved in the federal court. And there are significant issues that I can't go into in the appeal brief because of your jurisdictional limitations that will come out in the court. And I can assure you that this process has been terribly unfair to my client, terribly unfair to a lot of people who have been asked to submit at their expense, their great expense, applications here that I don't believe have been properly scored.
Is there anyone else wishing to speak? State your name and,
Can you hear me?
yes, sir.
Good evening, Chuck, commissioners. Thank you for the opportunity. My name is Mr. Manjo. I am a developer, and I am also a conditional holder of the 939, 935 Orchard Lake. The conditional letter that I received from the city gave me an opportunity to move forward to redevelopment of that site. Once I got that letter, I made sure that we were good to go. So I communicated with the planning department and what they need for us to move forward. They gave me all the tools that I needed. They were very helpful. We were the first one to move forward and to start the process. The Planning Commission helped us through the process. They approved the site plan. We went to the zoning department. They approved the zoning for the property. Came in front of the council. Everybody was excited about the first applicant to move forward. I put out almost a couple $1 million into the project, order material, started the process so we can start the construction to build a beautiful building. All of a sudden, I got this letter from the city stating that I'm no longer approved. It kind of, I look back and I said, well, if the city would have told me you're not approved until you're approved, then I would have pulled back and waited until see what happened. But when the city gives you a green light and a letter says go ahead, not sure what else to do. Do I sit down or do I go ahead? So common sense, if you folks understand what the letter that means is for you to move forward, then you go ahead and you move forward. You invest in a property and you start building based on everything that the city told me to do. So I sit here with a couple $1 million out of my pocket arguing because of someone else had appealed, which has nothing to do with me. That's something the city and common citizen has to deal with, not me. Because now if you have 6 other appealants in different districts, if they win the appeal, what's going to happen to the people that they had their conditional? Are they going to fall? If they already started construction, what happens there? Have you guys thought about that? Do you have a plan? I mean, you're playing with people's hard work and money here. It's not easy for us. Thank you.
Thank you, sir. If there's no one else here to speak, then we will close public comment. Next item is item number 3, is the discussion on nature remedies of Pontiac LLC Non-Overlay Provision Center. And just as a point of reference, as far as the appeal goes, they are seeking the awarding of an additional 4 points for a maximum of 8 points under the category of facility planning. Okay. All right. Is there any discussion from any council commissioners?
I'll go first then, if that's good.
Just for, if you want to go last, you can. So.
Yeah, well,
Okay.
okay.
That's, I know
So
made
you
that
want to go
request, so-
first then?
Yeah, I can go
Okay.
first.
All right.
Okay. Again, the Nature's Remedy appeal, they want additional 4 points for a total of 8 in the category of facility planning. Possible scores in this category were 8, which is satisfactory, 4, somewhat deficient, or 1, very deficient. And again, they received a score of 4, somewhat deficient. And the reasoning given by the score was that the scale diagram / site plan not signed and sealed by a licensed professional purveyor. On page 7 of the application provided by the city, under scale diagram, under section 8C19, it states that such scale diagram must be in the form of a property survey prepared by a licensed professional surveyor. The cover page for section 8C19 on page 14 of the application packet submitted by Nature's Remedy under planning facility includes the following language: scale diagram in the form of a property survey prepared by a licensed professional surveyor. It shows it was prepared by TDG Architects. Nature's Remedy did provide a location map in section 8C21 that was prepared, signed, and sealed by a licensed professional surveyor per the application requirements of that section. As a result of my review of this appeal request, I have concluded the following. The application provided by the city to applicants clearly stated that the scale diagram under section 8C19 was to be prepared by a licensed surveyor. Nature's Remedy submitted a cover page for section 8C19, acknowledging awareness of the requirement to submit diagrams prepared by a licensed professional surveyor. They also acknowledge awareness of this requirement in a subsequent section. Now, whilst Nature's Remedy did submit diagrams prepared by a licensed professional surveyor in a subsequent section, they failed to do so in the section under appeal. The original score of 4 was upheld throughout the various layers of review that have been established by the city. In addition, the hearing officer heard the appeal and denied the addition of 4 extra points. I am in agreement with the decision of the hearing officer. Any other comments?
The comment that I would like to make is basically the same. We reviewed the same information the first time that we reviewed your application. And based on the information that was just given, I observed the same thing the first time around. And now coming back for an appeal, there's absolutely nothing that has changed in the package. The ruling was stated there from the beginning, and I agree with what the hearing officer stated. Coming back a second time with the second appeal does not change the fact of what was in there the very first time we reviewed it. Does not change. There has been no additional information that could be added to the package. So I agree with the scoring the first time around, and I agree with it the second time.
Any other comments?
Yes, okay, I'm gonna just add to what Mr. Wilson and Mr. Ford have already said. One of the things that was all over the application forms and stuff was also when it comes down to, let's say, little noodle things, the clerk has the right to assess, evaluate, score, and rank. And I think he did the right job on that. So I don't see anything changed since then. We had the affidavit, but that was added after the original application. Yeah, it was after the original application. It's from Brian Gill, yeah.
Excuse me, sir, this is not a time for comments. We gave you a chance. Thank you.
So I'm not changing my mind either from before. So.
Excuse me, sir, you're out of order. Please respect the commission. We respected you. Please respect the commission. Thank you.
So then what I'm saying is that nothing has changed either, so, sorry.
Any other discussion?
No.
Nope.
Okay, hearing no more, we'll move on to item number 4, which is a resolution on Nature's Remedy of Pontiac LLC Non-Overlay Provision Center. And what I'm going to do is I'm going to read the resolution, and at the end, we will take a vote on it, and a vote of yay will be to deny, a vote of no will be to approve. A vote of yea will be to deny the, or to approve the resolution, and a vote of no will be to deny it. Okay, we clear on that?
The appeal, yes.
Okay. All right. A resolution of the Pontiac Medical Marijuana Commission. A resolution on Nature's Remedy of Pontiac LLC, 939 Orchard Lake Road, non-overlay appeal. And whereas ordinance 2357B gives the city clerk the responsibility to score and rank applications for medical marijuana provisioning centers using a 130-point scoring system and awards permits to the 20 highest scoring applicants. And whereas the city of Pontiac adopted ordinance 2363 to include medical marijuana facility uses in designated districts, and whereas ordinance 2363 provides that no more than 5 provisioning centers shall be established in the C-1, C-3, and C-4 zone properties combined outside of the medical marijuana overlay districts, non-overlay. And whereas the city clerk ranked and scored provisioning centers in the non-overlay using a 130-point scoring system. And whereas Nature's Remedy filed its application for a provisioning center permit in the non-overlay district on January 24th, 2020, and whereas in this appeal, Nature's Remedy seeks 4 more points in facility planning over the issue of not having their sealed diagram survey signed and sealed by a licensed surveyor, and whereas Van Gustafson, the city planning manager, performed the initial review of Section 8C19 and awarded 4 of 8 points somewhat deficient, stating scale diagram / site plan submitted was not signed and sealed by a licensed professional surveyor. And whereas the clerk's expert planning advisor consults from Giffords, Webster, Jill S. Baum, AICP, and Eric M. Paish, AICP, performed a compliance review of Mr. Gustafson's scoring of Section 8C19 and the application, and they confirmed and certified under penalty of perjury that a score of 4 out of 8 was consistent with the scoring requirements. And whereas the clerk reviewed all the materials, including the recommendations of the numerous reviewers, and on August 2021, the clerk notified Nature's Remedy that it received a score of 125 on a 130-point scale and was tied for 5th out of 48 applicants. And whereas Nature's Remedy filed an appeal of its initial scoring to the hearing officer on September 7, 2021, and whereas following an administrative appeal hearing on October 29, 2021, on November 18, 2021, hearing officer Cheyenne L. Binyee of the Grewal Law Firm recommended awarding an additional point in the facility sanitation category with a revised score of 126 out of 130, and the hearing officer denied the request to adjust the scoring related to the facility planning / scale diagram. And whereas the hearing officer recommendation of November 1828 summarized Nature's Remedy argument that it did submit 2 scale diagrams, but they were appended to the end of the submission entitled Planning Facility, appellant further contends that the scale diagrams were stamped and sealed by a licensed professional surveyor. Appellant believes these documents were overlooked during the scoring process because it was appended to the end of the submission on pages 26 and 27 of the document. And whereas the hearing officer, Cheyenne Binyee, made this finding, a closer read of the scorer's comments indicate that the scale diagram was submitted and reviewed during scoring, but it was not signed and sealed by a licensed professional surveyor, which is why points were deducted. Appellant points to its Exhibit A, which includes two Google Earth maps, which are signed and sealed by a licensed professional surveyor. However, the maps do not illustrate all available parking spaces and specifying which parking spaces are handicapped accessible as required. As such, the city clerk's score was not arbitrary or capricious. The hearing officer recommends the city clerk's decision to award 4 points for this category be affirmed, and whereas on November 29, 2021, the clerk notified Nature's Remedy that he concurred with the recommendation of the hearing officer and that Nature's Remedy was now solely in 5th place, and whereas the city clerk issued a conditional approval letter to Nature's Remedy on May 27, 2022, and whereas a conditional approval requires compliance with all applicable ordinances which limit the number of provisioning center facility permits in a non-overlay to the 5 highest scoring applicants, and whereas Nature's Remedy application and conditional approval letter was subject to the judicial review process of Section 16 of the ordinance, and whereas Nature's Remedy had actual knowledge of the judicial review process after the May 27, 2022 conditional approval letter because it sought judicial review of this commission's May 12, 2022 appeal decision in Nature Remedies Walton Boulevard Overlay District property as evidenced by Nature Remedies filing a claim of appeal on June 2, 2022, with the Oakland County Circuit Court, case number 2022-194385-AA. And whereas the Medical Marijuana Commission conducted a remand hearing on December 27, 2022 of the MPM-R9 DBA Common Citizen reversal by Oakland County Circuit Court Judge David M. Cohen on December 9, 2022, and the commission awarded MPM-R9 DBA Common Citizen 4 more points for facility planning and 1 more point for the facility sanitation plan and contract, which resulted in Nature's Remedy dropping out of the top 5 applicants in a non-overlay. And whereas the city clerk informed Nature's Remedy of Nature's Remedy of Pontiac, LLC, Nature's Remedy, on December 29, 2022, that it was now ranked 6th in the non-overlay. And whereas Ordinance 2357B allows an applicant to appeal to the Medical Marijuana Commission, and Nature's Remedy filed this appeal on January 27, 2023. And whereas Nature's Remedy attached to its written statement of appeal dated January 27, 2023, an affidavit of Brian Gill dated March 2nd, 2022, that was not included in its January 24, 2020 application or in its appeal to the hearing officer. And whereas applicants may not supplement their application with documents that were not included in the original application materials, the City of Pontiac Medical Marijuana Facility Application Rules and Procedures for Hearing Officer's Appeal dated March 1st, 2021 provides at number 5, written statements of appeal shall not be limited exclusively to the information submitted with the application. An appellant may not supplement their application with their written statement of appeal. The hearing officer shall not consider any information submitted in an applicant's written statement of appeal that was not part of the appellant's application prior to the denial. And whereas the commission finds that the clerk and his staff and consultants conducted a rigorous, extensive review and scoring process, the scoring by the clerk and the hearing officers detailed findings and recommendations which the clerk accepted were reasoned and based upon principle, based upon more than a scintilla of evidence, and were not arbitrary and capricious. The final scoring of 126 out of 130 points was supported by substantial and material evidence. The record is absent of any indication of the clerk and hearing officer committing clear error under the review standard. Now therefore be it resolved, the Medical Marijuana Commission finds that the total score of the Nature's Remedy of Pontiac, LLC, for its 939 Orchard Lake Road location in the non-overlay is 126 points out of 130 points, and Nature's Remedy of Pontiac, LLC's appeal for 939 Orchard Lake Road, Pontiac, Michigan, is denied.
I would like clarification as to that you've drawn actual knowledge.
Sir, you're out of order. You are out of order.
You have to give
You are out of order.
ask for clarification.
You are out of order.
You can call the police to have me.
You are out of order.
Let's
You are
calm
out of
down
order.
here. Let's calm down here. Let's calm down here.
You conclude that we had actual knowledge of that appeal. There's no record evidence of that. We
You
did
are
not
out
have
of
actual
order.
knowledge of that appeal. We did not have actual knowledge of
You're
anything
not-
that was going on in that appeal.
Mr. Allen, you're not
Ms.
helping
Porras,
your
Ms. Porras.
case.
Right here.
Ms.
I'm
Porras.
making my record for the judge that's going to review this.
All right.
Okay.
It's outrageous what you're doing.
Okay.
And I'll point out that you.
Can I get a motion to approve the resolution?
Further reason for you.
I move that the resolution that was just read be approved.
Can I get a
Second the
second.
motion.
been approved? Second. Roll call.
Wilson,
Yes.
Brath,
Yay.
Ford.
Yes. This motion is denied. I mean, the resolution is approved and the appeal is denied. Okay, next item is called for an adjournment. Right now, it is approximately 6:31. Can I get a motion to adjourn?
Motion to adjourn.
Can I get a second? I've been moved in a second. Roll call.
Ford,
Yes.
Wilson,
Yes.
Pratt.
Yes.
We are now, this
You, sir,
meeting
are
is
not-
now adjourned at 6:32.
You are not helping your case, let me tell you. You need to control your temper.